Okay, it is exactly 8:30. It is Monday, November the 16th, and welcome to week two of constitutional law. And I am Richard Wright, and I'll be here, for roughly the next hour or so, sharing details and information with you. I still haven't had a chance to record that information I want to share with you about myself because I've been so busy getting this quarter started with the 3 classes that I'm teaching, but I will try to get that completed this week so you guys will be able to have that and learn a little bit more about what I mean by adversity is a springboard to success. But for now, I'm going to go right into the module this week, as I will not be covering this information again. So this week, you're going to deal with briefing a case. Now, I provided you with some information that helps you to be able to brief a case. And then there's some information in the module itself. And then it's been brought to my attention that there is also some information available for briefing a case under the following link. I think it's this one. Let me see. I think this is it. No, this is not it. Might be under the guides or resource. I know it was a student. Let me see. I can tell you who told me, who asked me about that. Let me go to course messages. Yeah, it was Rebecca. Under, yeah, here it is. How to write a legal brief under this frequently asked question under Library Learning Center. Okay, here it is right here too as well, which is really the same information that we've already included. So you could utilize that information. But this is a basic, and one of the things that's important in here that I noticed that I really like is that they deal with the concurring and dissenting opinions and the reasoning behind it. And I'll be talking about that tonight. Okay, so yeah, so that's something that will benefit you. So anyway, you're going to deal with the facts, the procedures, the issues, the holding, the reasoning. And then also, you should be aware that I also grade you on not just the reasoning, but also the concurring and dissenting opinions. Very, very, very important. It's not exactly included in here, but it's actually part of the reasoning. It's actually part of the whole proper thing about briefing a case. So utilize that information, but be sure that you include concurring and dissenting opinions. And I'll explain that a little more in detail when we get to it. So you have this module. By the way, I sent you the PowerPoints for that. And then this week, you're going to select your topic. So You're going to select a topic related to the Fourth Amendment. Explain why you chose that topic and use APA citations and references. Very important. Okay, so it's APA. Make sure that you do that. Okay. And then finally, today is our week 2 lecture, and the rest, as you'll see, will be from 8:30 to 9:30. The recording is down here for week 1. Week 2 will be here also. Okay. I see that Rebecca has joined me. I want to let you know that I used your information that you supplied me concerning the librarian learning resource questions about a brief. So I shared that with the class today as well. So thank you again for supplying that. But as I said, it matches. It's just another place to find the same information. What I really like about that, again, is that they stress the concurring and dissenting opinion as a requirement. A lot of times people think that it's not necessary, but I'll explain in detail why it's so important as I get to that. Okay, so now let's quickly look at our course calendar as we will do each week. And here is where we are. Today is the 16th. You have your reading assignment, Chapter 4, and Appendix E. I sent you the PowerPoints for Chapter 4. Also, you can read Equal Protection Under Law, which we're going to be talking about, and Briefing a Case. So we're going to talk about that too in just a few minutes. Then your initial post tonight, is it really equal? And I'm going to comment about that. Okay, is it really equal? And then prisoner equality, talk a little bit about that. And then your reply post now will be due on Saturday. Each post from now on will be due Saturday until reply post until we get to the last week, which I'll show you in a few minutes. And then your written assignments are what I just shared. The Fourth Amendment Project, which I talked about, and I'm going to talk about more in detail in just a minute. And then briefing a case. Briefing a case. Very valuable tool as we lawyers used. Very valuable. Paralegals use it. Very, very, very important. It's basically an outline of a case. And then next week, of course, we'll have our lecture on next Monday. Okay, next week will be not a short week for you guys or for me so much, but Thursday the 26th is Thanksgiving, and then Wednesday the 25th. Okay, going to be a little different Thanksgiving for us at the Wright household because we are totally going to try to follow the guidelines. Only people that'll be at our house will be the people that live at our house. And that's up to you to decide which way you're going to go. But you know what? I want to tell you guys, I like safety and I like listening to professionals. I respect professionals, and the CDC and Dr. Fauci, and I love him, and other medical individuals that I respect. I believe in what they're saying. So let's operate accordingly. Maybe a lot of people are tired of it. There are people who are going around saying the opposite, but I'm a 70-year-old African-American male, very knowledgeable and educated, and the wisdom that I have came about from following, listening to experts that I agree with. So anyway, that's my spin on it. So enjoy your weekend that'll be coming up. Of course, don't make sure you get your assignments done, because anyway, I'm not going to talk about that till next week. I'm jumping ahead. All right, but then I do want to show you what I do every week, how quickly this quarter ends. The 18th of December, 11:59 p.m. Central Standard Time. Some students who took this course in T1, that the course ended on the 10th of November. They sent me assignments for the 11th of November. I couldn't grade them by school rule. There is no way I could have graded them. There is a way, but I'm not going to discuss that. But that's something you discuss with your advisors and deans. But the point of the matter is that you got to adhere to that deadline. I can't extend it. I extend a lot of things, but I can't extend the quarter unless leadership tells me to be able to do that. But so far as I know of, the 18th, 11:59 p.m. Central Standard Time will be the end of this course. So now let's look at week 2 announcement. So our announcement tells us that we're going to talk about equal protection under the law. And I've already said the reading assignment is chapter 4 and appendix E of the textbook. We're going to discuss equal protection under the law and how to brief a case. And then your discussion assignments that I shared, is it really equal? And prisoner equality. Initial post, as I said earlier, is due Tuesday night, 11:59 p.m. Central Standard, which is tomorrow night. And your reply post is due this Saturday, 11:59 p.m. Central Standard Time. Finally, be sure to complete the written assignment, briefing a case, and the Fourth Amendment project, which we're going to talk about in just a few minutes. Pay attention to rubrics. Rubrics are very important. I say that so much. And then my motto is start strong, finish strong, but adversity is a springboard to success. Again, I've been so busy, I haven't had a chance to put together that recording, but I will do so this week. Make sure you can have a chance to listen to it. It won't be graded for on it, but it'll tell you a lot about your professor. I'm one of those people who believe in being open to my students. Okay. So now let's get into equal protection under the law. Assignments. Okay. So now let's talk about the course project. The course project. So in this course, you will be doing a project that relates to the Fourth Amendment. And you will have each week various issues, weeks 2, 3, 4, 5, and then finally week 6. You will complete the assignments. Each assignment is graded independently. However, be aware that what you're doing is you're building for your final paper some information that you'll be able to utilize. So it's very important that you get these done contemporaneously with the week. So what you're supposed to do is look up the Fourth Amendment in your text on the internet or in the library. Review some cases and secondary sources. Someone thinks that cases are secondary resources. Secondary resources or sources are very simply articles, very good articles are law review articles. There's plenty of law review articles on the Fourth Amendment. There's a myriad. And so you're going to look up the Fourth Amendment. Now, after you've done that, and after you've reviewed this amendment and the law surrounding it, pick an area within the Fourth Amendment that you want to consider to research further. There are many issues, and you want to research further. Now, I have some that I usually talk about, but there are things that you can do. You can deal with stop and frisk. You can deal with an issue involving what the Fourth Amendment does, what you have to do pretty much to satisfy the Fourth Amendment. In most cases, that would be, of course, to obtain a warrant. And we'll discuss that a little bit more in detail. But you're going to find just a few cases, maybe 2 cases at the most at this particular point. And then you're going to write a 1-page paper indicating the area you chose under the Fourth Amendment and why you chose that. What is your reason for selecting it? Maybe it's a personal experience. Maybe it's just a general interest that you have. And then, of course, your paper should be properly formatted, APA, and all of those requirements. And you know what those are because we covered those in detail during week 1. Then you submit your papers in a Word document. Sometimes students want to submit their papers as a PDF. You're going to get a 0 if you do. And the reason why is because I need to be able to edit, look at, and then most importantly, be able to run your papers through Grammarly, as I will do every single one. And I will be doing that each week. Not for discussion posts, I won't be doing it, but those should be in Word too. But the point of the matter is that it's important for you to understand that the procedures that are set out in the modules don't ever say use PDF documents. They always say use Microsoft Word documents. If you have a problem, contact personal support. If you can't find the number, here it is down here. It's at the bottom of every page, not this one right here, but it's at the bottom of the pages for the assignments themselves should be. Let's see. Used to be able to see it. Oh, it's not here. This new setup they've given us has changed a whole lot of stuff. We have to get used to it. But contact personal support. The number for personal support, I think if you go to the course homepage, let me take a look, but I think I'm right. Nope, they took it out. It was in the bottom of every page that you saw, but it is in your welcome announcement. There it is. 866-693-2211. It's available right there. And I think it is also available under your resources. Let's see. Here we go. Should be on here, I thought. Let's see. Okay. I do know one place it definitely is, and I'm going to show it to you. Okay. Yep, it's not there either. Okay, let's go back to let's close this out. Oops, I don't want to do that. Here we go. Let's go back to the home. Yeah, log back in. Okay. Okay, this is very irritating. But then we're just starting today. Need help. Let's see. Well, it's not showing up. Anyway, for sure. Oh boy, this is really going to be fun learning how to navigate this first. Get rid of this content. Okay. Okay. Anyway, you do know where to find it regarding, that's why this welcome announcement, again, is so important. There it is. There it is. Okay, so you'll see that right there as well. I think I'm going to put a link on my course homepage too, just to help you guys out. I'll do that later. Okay, let's go back to where we were. But the key thing is, if you have a technical problem, personal support should be available to help you. Okay? Any questions about the course project topic selection so far? Any questions? You can type it in the chat if you have a question. Okay, all right. Yeah, I'm very irritated about not being able to find the information that I was looking for because it was all over the place before. So that's one of the things. Maybe when I go to finish my training, which today being the first day that we're supposed to start, then I will know more about that, and we all will learn more about this new resource. It's like any other thing. When you get something new, you got to learn how to navigate the new thing. All right. In the meantime, let's talk about briefing a case. So we're going to use as a model to help you brief a case, the famous Terry versus Ohio. And notice this. This is the citations. When you cite cases in my courses, I require not Oyez, not Justia, or Fine Law as your citation, unless there's a case that like is right now just coming down. I mean, like the last few days. But most cases you can find the correct citation. And the way it's written is with the party's name, the volume of the United States Supreme Court. This is the official citation. U.S. means Supreme Court. And page 1. And the year's issue is 1968. If you leave this off, it's not complete. If you leave this off, it's not complete. If you just put this, it's not complete. So I'm just mentioning that now because it becomes a point of contention further down in the weeks, that get into the habit of citing the cases. That's my legal background that reminds students that it is so important that you don't assume that somebody can just find it. Well, no, they can find it if they use this. So anyway, follow directions given for briefing a case. Now, again, I sent you some information, and then I'm going to go over the information in the module in a few minutes. And remember one thing about briefing a case. Now, let me say this to you. You do not, I repeat, you do not necessarily have to worry about APA for briefing a case, because in itself, the setup follows the information that should be original from you anyway. You should not be utilizing somebody else's brief that was already written. You do not, I repeat, do not copy and paste. You'll see that as I talk about that in a few minutes in detail. And so I'm going to cover that very detailed in just a few minutes, briefing the case. So it's the Terry versus Ohio case. Everybody should do this one case for this. And it helps you because you're going to be briefing cases later on in this course. And several of you know how to do this already, which is awesome. So make sure you do so. All right. So now let's talk about the discussion post. Is it really equal? Well, the Constitution has an amendment that says that everyone has equal protection under the law. Do you know what amendment that is? You can type it in the box. That's nope. Now, yes and no, because that deals primarily with search and seizure. Yes, yes, yes. A lot of students say that, but the 14th Amendment, now let me explain to you what the 14th Amendment did. It did a couple of things. The first 10 amendments of the Constitution did not, I repeat, did not apply to the states. It applied only to federal law. Once the 14th Amendment was done, it required that the first 10 amendments and all amendments relate to the state law as well. So the Equal Protection Clause, which we're going to talk about in detail in just a few minutes, the issue for this assignment is it really equal? Is it really applied properly? Do you think that it actually accomplishes what it says? I think we can take as common knowledge, or as we say in the law business, judges will say judicial notice of the fact that equal protection means equal. And if you look at equal in the dictionary, it means the same for everyone. That's what it's supposed to mean in a nutshell, but we're going to elaborate in detail. So anyway, you're going to discuss in your post, what are some instances where people are still treated unequally, even though the equal protection law of the Constitution exists? Then, is it fair? And then, how can the legislature go about making it more equal for everyone? As you should know, that our Constitution sets up our government into 3 sections: the executive branch, which consists of the president and the cabinet; the legislative branch, which is the House and the Senate; and then finally, in terms of interpreting the cases, as I said last week, based on the Marbury versus Madison case, that it is the judiciary or the courts that interpret the laws. So each have separate roles. So the question asked this week is, how can the legislature go about making it more equal for everyone? And I'll talk about that in just a few minutes. But a hint is they're the ones who pass the laws. Okay, now, leaving that for a minute, prisoner equality. Equal protection comes up in prisoners' rights cases. And question is, do you think inmates should be allowed to file as many petitions as they please? Would a limit on petitions force inmates to be more selective in their petitions? Why or why not? I will make you aware of the fact that there are laws, and there is a federal law, particularly that deals with before petitions are filed, there must be administrative procedures exhausted. And the reason is because of the volume of cases that petitioners would file in terms of their rights. I remember as a lawyer having several individuals come to me who were inmates, who were some of my clients, and they would bring me petitions that were handwritten or typed by one of their cellmates or themselves. They had gone to the law library because that's one of the rights that inmates and prisoners have. And they would write their own petitions, and then they would tell me I should file this. Well, I respectfully declined filing them. And the reason why is because I asked this very simple question: where did you get the information for the petition that you want me to file? Well, my cellmate, he's been in a while, and he's an expert at filing petitions. I said, okay. So he's giving you a petition to file, saying that if you petition, you can probably be released. Wouldn't you ask the question that, don't you think that you would file that petition for yourself if it worked? Or if you filed it, did it work? So in other words, why are you giving it to me? You get my idea of what I'm saying? You understand what I'm saying? Yeah, because we call it the floodgates issue. The system would be bogged down. And I have seen some handwritten petitions and some filed by individuals. I think, you're familiar with wrongful convictions. I think that's one of the issues I think that you're interested in, Rebecca, as I work through myself. But I can tell you that most of the petitions that are submitted by those individuals are not very good. They need good lawyers, and they need to have projects like the Wrongful Conviction Project, of which I'm proud to be a part of for life, and that's Northwestern University School of Law. I continue to follow their victories because they're very detailed and very thorough and utilize the law to the max. And so that's just one example, because it's so important that individuals understand their rights, but they also need to use experts. You heard me talk about that earlier. And most inmates are not experts. They can make suggestions to their lawyers, and sometimes some are pretty good, but most of them are not. Most of them are not. So, and I'm not even talking about the grammar and all of that stuff. I'm talking about the approach that they take. So anyway, we're going to talk about, you'll see me post something that shares with you. And if you do research, you'll be able to find about how they limited and what the legislature did to fix that, or attempt to fix it. And then your live classroom, you give me your phrase All right, or word. All right. Let's talk about the topics. We got about 25 minutes roughly. So let's deal with the two issues. First of all, equal protection under the law. The 14th Amendment is what I was saying to you earlier. Section 1 set forth that all people should be treated equally under the law. That's the premise of what the 14th Amendment is supposed to stand for. But let's read it together. All persons, notice, see, pay attention to the words they use. All persons born or naturalized in the United States. So that means if you're born in the United States, naturalized, you go through the process and become a citizen. And subject to the jurisdiction of the United States, are citizens of the United States. It's just like there's no difference in if you were born or naturalized in the eyes of the law, as there's no difference between if your parents adopted you legally or gave birth to you. They still are your parents. That's the same concept that's utilized here with dealing with naturalized. There's no asterisk on your birth certificate or none of those things. Okay? So, and you have the rights and privileges of those individuals who are born here. So that is why I frown very seriously upon people who are born here believing they're better than individuals who are naturalized. That ain't true. And that is a mockery of what this country stands for in terms of democratic, which when you hear me say democratic, I am not talking about my my position as an individual, Democratic or Republican. I'm not talking about that. I'm talking about democracy, which means that the majority rules under situations, as you know already, that the majority of the people have voted for Joe Biden to be president of the United States. And that's the regular vote. But we have a process in the Electoral College where you get 270 votes based on winning in each state, and you become president of the United States. Guess what? If you beyond that, then you are the duly elected president and will be sworn in on the 20th of January. That is our law because we are a democracy. Now, so let's continue on. As a citizen of the United States and the state, notice it says in the state, that's why this was so important, wherein you reside. Okay? So that whole sentence comes together and ends with it's pointing towards the states. The states. Okay? All 50 of our states. Then it says no state. Now, none of the states shall, and when you see the word shall, that means it's mandatory, okay? Make or enforce any law that abridges the privileges and immunities of the citizens of the United States. So that means that there should not be laws passed, or the state should not enforce any laws or put on their books laws that violate the privileges and immunities of citizens of the United States. No exceptions. Now, nor, as if that wasn't enough, shall any state deprive any person of life. That is why we have the issue of of what we call excessive force that takes place in law enforcement, where a person may be killed improperly, or an individual is killed by a private citizen improperly without a self-defense mechanism or satisfying the requirements of the statutory laws on the books that give an exception for when a person can do that. And it extends all the way to the Eighth Amendment of cruel and unusual punishment, which attaches to the death penalty, which basically applies the reasoning that you cannot execute a person without the rest of this due process of law. Now, it says, so a liberty that goes to incarceration and locking someone up. They have a right to due process of law. They have a right to a hearing. They are presumed innocent until proven guilty. Or you cannot take property without due process of law. That is not only what our criminal law says, but our civil law says. There you have a hearing. You have a right to a trial and to be able to provide proof and evidence, to be able to protect yourself, or either to provide details why your allegations are true. So just because someone says that something is not proper, there is an alternative, and you can file a lawsuit. However, once that lawsuit is adjudicated, then you have a right to either accept it or appeal it. And you can appeal it in some instances. Listen to me. If there's a federal question, all the way up to the United States Supreme Court. Nor are we to deny any person within the jurisdiction of these 50 states equal protection of the laws. So now we get to the nuts and bolts of what that question that we have in the discussion forum. And the question that you have to ask yourself is, it's not about whether you feel or believe, but is that person being treated equally regardless of race, religion, sex, national origin, political party, or any of those things? And so what we pride ourselves in this country as a democracy is giving everybody equal protection of the laws. Now, I put that in quotes because unfortunately, there are arguments made that because of discrimination on the basis of race, sex, national origin, there are some violations of what we believe of the 14th Amendment Equal Protection Clause. And so we have a series of cases to deal with that. And so right now I want to focus on one area that is key, and that is the right to a fair trial. That's under the 6th Amendment and a speedy trial. And we deal with two processes for which there are trials. They're what we call bench trials, where the judge is the one who decides the outcome of the case. Or there is what we call a jury trial, where we lawyers would go through a process called voir dire, which means to seek the truth, where we are given the opportunity to question individual citizens in the jurisdiction where the case is being tried to determine whether or not they could be fair and impartial to protect the rights of that defendant. And so it is so important that we operate with it. And so I'm going to tell you a little bit about it here. I've made a career out of this. It says here that it is one of the concepts under the law that affects our criminal justice system, that is jury selection. And so we go through that process, and we use what's called peremptory challenges now, or preemptory challenges. And what that means is that by statute in the jurisdiction where the case is tried, you are given the opportunity to dismiss someone after you've questioned them without giving the reason why you do it. Now, the real reason that you do it, let's be straightforward and honest about it, is because you believe that they will probably not agree with your presentation, or they will not be on your side in the case. That's really the bottom line and essence of it. And, you know, that's okay, because that's what this process is all about. However, you do not, in terms of stating the reason, set a pattern of discriminating against individuals. How should I say this? Yeah, race will play a part in it. It will. It just will. However, if that's your sole, if it's determined that it appears that you're stacking the deck just based on the race of the individual and not other issues relating to your voir dire questioning, such as maybe their education, or maybe they have said something about that they believe that the person is guilty based on information that they've discovered before coming to this case. In that case, then you don't necessarily have to use a voir dire. You don't have to use a peremptory. The judge should remove that person. Should. And it would be an error or a possible basis for a mistrial if the judge doesn't do so properly. But the system is designed so that you have to have a reason other than the race. Okay? If a lawyer, it says, believes that the other side is removing a juror based on solely, you got, it's really like a chess game, guys. The lawyer can file what we call a Batson motion, which came out of the case of Batson versus Kentucky. And the key thing in the Batson case is in this language. I have read the case, and it was after I had graduated from law school, because I had to deal with these kinds of issues constantly as a criminal defense lawyer. Being a trial lawyer, I had to deal with voir dire. I had to deal with jury selection. And so the Batson rule, when we had our continuing education processes, we would talk about that. So anyway, the main issue regarding equal protection under the law from this case is, and this is really, as we say, this went to the heart of it. The same equal protection principles as are applied to determine whether there's discrimination in selecting the veneer, that is the panel, also governs the state use of challenges to strike individual jurors from the petit jury. Petit jury is just another name for jury. Although a prosecutor ordinarily is entitled to exercise peremptory challenges for any reason, as long as that reason is related to his view concerning the outcome of the case to be tried, the Equal Protection Clause that I just went over with you earlier, right up here at the top, forbids the prosecutor to challenge potential jurors solely on the basis of their race, or on the assumption that because a black juror as a group will be unable to impartially consider the state's case against a black defendant. Do you remember hearing about some years ago, there was a lawsuit that was filed, and President Trump made a statement about a judge trying the case because he's not a big Muslim fan. Because that judge was Muslim, he didn't think he could get a fair trial. Now, that was a civil matter, but what I'm trying to point out to you, it reeks in terms of the conclusion that's reached in the Batson case. You get my point? You get it? You with me? Okay. And so the point of the matter is, but it's interesting. Somebody said and asked me this question, and I bring it up here. Why does it just say prosecution? Well, I'm glad you asked. Because in the normal course of selecting jurors, the defense will pick people that they like. But what the prosecution will oftentimes counter with is saying, no, that person will possibly be able to lean towards that defendant if that person is the same race of the person that's being tried. And our system under Batson says, no, what you got to have another reason other than that to use your peremptory challenge. And that's the point. That's the point. So there's some work that has to be done on Batson. If you look at what we call the prodigy of cases up under Batson versus Kentucky, if you, for example, did what we call a search under using LexisNexis or Shepard's. Have you ever heard of Shepard's citation research? I know you have. That is what we utilize to determine. Yes, and you know what? That's a very good point. If you're going to be a lawyer or a paralegal, because what you're doing is you're utilizing a case decision. That this is the 86 case. There have been cases decided under that, subsequent to that, that is valuable to bring it up to date. Or there may be a case that simply overturned it. Or you may be able to argue, as we lawyers say, distinguishing the facts, that this may be close to it, but we can put it in the vein. You remember those kind of conversations, Rebecca? Yep. And so we use that. As a law librarian, I learned how to do that manually. You learned how to do it by pushing buttons, did you or did you not? Yep, that's it. That's it. That's it. And that's what we call distinguishing cases. But the point of the matter is that you learn your process of Shepard's research by utilizing computers, right? Yeah. But yours truly, your professor, as a paralegal, we did it by the old-fashioned way. We used the Westlaw system, the Key West system. You know about that, right? The Key West system. Yes, and also you know about American jurisprudence, or AmJur. They have their system as well. You probably know about Corpus Juris Secundum, which is a body of laws that have been compiled in books that are utilized. You know about CJS? Yep. See, all these things are important in being able to utilize this. And that's so anyway, the bottom line is that we can come forward and we can determine now. One of the things that's going to be argued sometime, and I hope soon, will be applying it to age, to gender, and religion. The gender issue really should be coming on because at this time, the Civil Rights Act had not amended and added LGBT and all these things. So, but it's going to take, as you know, someone to bring an action challenging it using these as issues. So stay tuned to that channel. And in the process of researching these cases and shepherdizing these cases, you'll be able to find out about that. All right, so we're almost done here. Ooh, I used more time here talking. Well, discrimination in criminal justice, all this points out to is statistics. And it says very simply that there's something wrong with the system because of there's some issues with representation or individuals who are incarcerated and based on race. And it looks at the law enforcement individuals as it says, 1 in 4 officers were members of a racial minority. That has changed, thank God. And, you know, it's not that a person of a different race can't be a good law enforcement officer, but it is so important that people understand that there are people in the community. For example, I'm speaking in terms of myself as an African American. There are people who really want to look at the law enforcement people and see someone that's like them, that looks like them. I saw something on Nightline the other night, last night. It was actually from the other day because it wasn't on last night, but it was recorded, where there were these young Black kids and these young girls, and they were saying they were proud of the fact to see a vice president that looks like them. Well, that's the same thing that I felt as a African American when Barack Obama was selected as president. It's not a discrimination issue, it's a pride issue. And so anyway, the point of the matter is that there should be some parity in terms of law enforcement, should be fairly distributed across based on the population really of the community. That's one of the things, one of the big criteria. And then there's some statistics here. It says a third of the federal officers were members of a racial or ethnic minority. And this included 17.7 who were Hispanic or Latino, and 11.4 were Black or African American. And it said in 2002, racial or ethnic minority officers comprised 32.4 of federal officers. So the point of the matter is that moving forward to balance it out and consider the demographic makeup of the prisoners, law enforcement, and the courts themselves, talking about the number of judges for racial disparity. For example, I live in Kendall County, Illinois. I don't think we have any African American judges in Kendall County. I don't think so. I know in Will County, there's at least one I know of because I know him real well. But the point of the matter is that it doesn't even fit close to what the population is in these areas. So there need to be some parity. And so that's the whole issue about the equal protection under the law. And, you know, as they say, on its face, it all sounds good. But how is it actually when it, as they say, when the rubber meets the road, for real, you know? Oh, okay. Okay, okay. I know where you are. Yeah, I know where you live. I know exactly where you live. I think you live out Route 6, right? Oh, yeah. Okay. I thought you lived in Diamond. Okay. All right. I know the deal. I know we're gonna get off at I-55 to get there. So I've been out there. So I know, and I know why it's called Coal City, because it's on top of a bunch of coal mines. And literally. Yeah, yeah, I know. That's like saying that people know about Chicago, but they don't know about Plainfield or yep, say yeah, but there's a bunch of mine under there. I done a lot of business out there, and I've met people who lived out there, and many people who've been out there forever were they came from families of coal miners. So yeah, that's why it's called Coal City. Yeah, I know that. But Diamond, I don't. I know there was a restaurant that I would see. Oh, okay. All right. So, so what you did was you lived in Romeoville, as we might say, boy, that's more urban. But then you moved into Coal City. Is like, okay, feel like you had gone back in time, right? I got a lot of colleagues that work with me. There's two street lights and a lot of traffic. There we go. Or somebody might say country. For real. Okay, I'm not knocking anybody, but you know what I'm talking about. You know what I will say this to you, um, and since you've mentioned that, I remember when I was out there, and I remember being followed by a police car. I mean, all the way through Diamond. When I got off of the expressway, because when you first get off of 55 heading west, you come through Diamond first. Am I right? Yeah. So the car picked me up right after I got off. And so I pulled over to see, yeah, you're right. You don't blink. But the point of the matter is that I pulled over. And when I pulled over, the police officer went ahead. And so then I pulled off again and left. Well, he was on the side up front waiting. And so when I pulled up, he pulled up behind me again. And so all the way till I got to where I was doing refis for a title company, and one of my assignments was to go to a home in Coal City, where I met somebody that let's see, his wife and them, they were assistant principals or principals. They were selling this popcorn and stuff at their house. In fact, they gave me some when I was there. I've forgotten their names, but very nice, very nice. But what I'm going to tell you is that the police car followed me all the way, and when I pulled out of the driveway, they were sitting right there and left. And I said, "Wow, I didn't know I'd get a personal escort." But I understood what was going on. But it's bad. It's bad. I got a young man that works with us. His last name is Brunich. I think that's, you know that name? Oh, well, uh, well, that's how you spell it. Well, Adam works at Rasmussen College. He in fact is in the admissions office at the Romeoville campus. Yeah, yeah, he's real cool. He's a real nice guy. We remember when the tornadoes came through, and we did a lot of different things, there. But yeah, yeah, I know several people throwing just names of people that I work with and know that are from that area, Coal City. Um, Rebecca, I can't think of Rebecca's last name. Pfeiffer. Um, her family lives there. She lives in Romeoville now, but there's a bunch of people that I know there. So, but Adam, everybody, when I mentioned his last name, I told him, I said, it's hard spelling your name because vowels are kind of scarce in that name. And he laughs at jokes about it. He's real nice. So anyway, you had your share of uh, tornadoes and stuff out there. That's for sure. That's for sure. But anyway, I'm a little bit over, but I want to talk about briefing a case. And briefing a case, as I said earlier, I kind of talked about it. So notice what it says. Remember I said you don't have to have citations and references. And one of the reasons is because it says do not copy and paste from another source. This should all be in your words. Now, I don't mind you copy and pasting the citation or the title. That's different. However, you need to find your case. But we already told you what case to use here. All right. And so just because you're able to find your case brief somewhere else does not mean you should use that brief. I said that. I run them through Grammarly, and I can tell the entire purpose of the brief is lost, because what the point of the matter is with the brief is to give you a synopsis of the case, and that's what it's all about. So it does consider the facts where you summarize. Do not copy and paste. Procedures, list what happened in the lower courts. Just a few details. Issues. In other words, what is the question that the court is seeking to deal with? From the issues question, now the question in a way that they can be answered yes or no. However, that's not it. It's not just, that whole section shouldn't be just yes or no, and that kind of thing. So yes or no, but what is the question from the court, from the issues in a way that they can be answered yes or no? That's how you're going to lay it out and write it. Then when you get to the holding, which is so important to us lawyers, you paralegals, and everybody who works in this business, how did the court answer? Yes or no? Then you don't just say yes or no, but you elaborate on it. Does this all sound familiar to you? Yep. So then the reasoning. This is an important section. Explain the rationale behind the court's holding. If the law is changing, explain that too. Such as the example I might give is, for example, if we go back to Brown versus the Board of Education, or rather Plessy versus Ferguson. You ever heard of Plessy versus Ferguson? You ever heard of that case? Look it up. Plessy versus Ferguson. That's the case that established and justified segregation in all type of entities, education, travel, and all of that. That dealt with setting the pace for Jim Crow. All right. And so you know about Jim Crow, right? You know about that. Okay. All right. So now that case said that. But in 1954, the United States Supreme Court, by the way, in the dissent of the Plessy versus Ferguson, was some information that was used to reach the decision to do away with desegregation in the famous Brown versus the Board of Education case, which I'm not going to ask you, have you heard of it? Because I know you heard of it, and you probably have looked at it before or studied it. You're familiar with that one, right? That's the case that overturned Plessy versus Ferguson. So when we start talking about the reasoning, some of that statement information from the dissenting and concurring opinions was utilized. So now it takes me to the last part, is that I also want you, and will grade you by whether or not you include the concurring and or dissenting opinion. Don't just skirt it over. You know, when we first started doing it, we said, oh, it's not that important. No, I found out the more I began to study that it was important. So only include this section if you believe it's important. Well, I don't try to approach it that way. I approach it as it's important because in some point in the future, whether or not you might think it's important at that time, some future case might be utilizing that position that the judges take. All right, so that's doing a brief. And then already we've kind of talked about this, the project overview, that what's going to happen. And this is just the schedule. Notice that today you're doing introduction to topic selection. Next week, case law and secondary source research, current topics. Fourth, interview. Fifth. Now, when we get to week 5, we are not necessarily going to require an interview. There's an alternate assignment that I prepared a few quarters ago because of the pandemic. And with the things being pretty bad now and going the wrong way, it's kind of hard to get an interview. And so we substituted that, but we'll talk about that when we come to it. But anyway, the key thing is week 1. Just focus on that, where you're going to choose an aspect of the Fourth Amendment and research the law surrounding this choice, including cases and secondary resources. And then when it says discuss a relevant event or case, that's when we start to move down here. So don't worry about all of that right now. Okay, and your final page is going to be 6 to 8 pages, and we'll come to that. Don't even worry about it, because each one of these weeks. So you're good. Just concentrate, just operate on the week by week basis, and understand the idea is that the final project is going to be a culmination of the previous weeks. That's all you need to understand. If you have any questions about any of this in here, don't hesitate to reach out to me. But it says here, each assignment will be graded independently. And I have provided the criteria for grading for each of these steps already previously with the rubrics, and it's already in the module. Okay, so I'm done. Done for this week. So I am going to give you a key, and I thank you for your input, Rebecca. I appreciate it. Starting from the beginning, when I utilized the information that you made me aware of about the brief information. So any questions? Okay, let me see this. Let me put this chat box up here. I believe you have access to Fast Law on Justice Study Guide. I think, yeah, it's Fast Case, I think. Okay, let's do this. Let's do this. I think I know what you're talking about. Let's go to, I'm going to go to, I want to go to this. Let's go to resources. Come on there. Okay. I think you're talking about this. Going to the guides and School of Justice Studies. Is this what you're talking about? Okay, wait a minute, let me see what you said. Then there is a section, Fast Case. Okay, let's see. Is that under? There it is. There it is. There it is right there. But it's here too. See it right here? But yeah, if you go to paralegal, okay, there we go. Okay, since I don't teach paralegal classes right now, but yeah, there we go. There it is. Fast Case. Thank you Thank you again. So if you click on that, then it opens up. That's what you're saying. Oh, awesome. Yeah, yeah. I think I talked about this with another student before, but because I haven't taught paralegal program, my good friend Kurt would have been able to say, "Hey, Richard." Yeah, yeah, you can find that is awesome. Thank you. I will forever be indebted to you on that because I will use that in other classes as well, particularly in criminal law. Uh, oh, did you say? Wait a minute, I think you said what I said. You said, yeah, Ashley. Yeah, yeah, I know Ashley. Matter of fact, I had Ashley. I had Cynthia Robinson. Do you know Cynthia Robinson? You ever heard that name? And I also had uh, Melissa. Come on, Melissa. I know your last name. Pitchford. Yeah, yeah, yeah. Oh, yeah. I had all three of them. But Melissa, I've had in about 6 classes. Yeah. Well, you know some good people. That's awesome. Yeah. But that's great. They are really good people and work with our students pretty well. As a matter of fact, now actually all three of them qualify as being able to help when you go to student tutor because now they have passed the class. And I can say they passed the class because I just finished grading them a couple of days ago. They were on the top of the class. So that's wow. Thank you. Awesome. Awesome. All right. So guys, I hope you guys paid attention to what she's given us. Again, just to summarize, you go to guides, and then you go to School of Justice Studies, and then you go to paralegal, and then you go to fast case. Thank you. Thank you, thank you, thank you, thank you, thank you, thank you. Okay, went a little long, but it went a little long because we started talking about diamond and places like that. So, which most of the students will listen to this and they'll say, "I don't even know what that's all about." It's what we call the uttermost parts of the world, or either if you want to get away from the city, go out there. Okay. Key phrase: equal protection. Give me that and you get your points. Well, thank you again for hanging out, Rebecca. You have really made my evening. And, you know, one of the things about a good professor is that, again, like I said, it's been a while. And then you have this, you guys have this different process. We don't do a lot of the research using those tools. I have used some of them, but I use like LexisNexis, and it was one other one that Westlaw. That yeah, Lexus Advanced now they call it now because it's gotten, but it's kind of expensive. Yeah, well, yeah, paralegal tutors and students, yeah, but it is expensive, but it's all right. All right, guys, and I'll say guys because only you on, but everybody who's listening to it, good night. Stay safe out there, and I'll see you guys next week. I'll have your thank you. I'll have your grades completed in the next few days for because actually tonight, just if you remember, last night was the night that you had to have your initial and reply post from week 1 in. Today is the day that I extended your written assignments from week 1, or written assignment, which is on that preamble, and your key phrase. So, all right, good night. See you next week.